Teachers can be dismissed for expressing their opinions in class. Does that sound right? Don't teachers do that all the time? Isn't that kind of what we get paid to do? Pardon? Depends on the topic. Okay. What if I'm talking about the Middle East situation right now and I say, you know, this war is awful. We should not be in Iraq. And in fact, I think, you know, we ought to be pulling out immediately. Is that okay? It's not? Okay, why not?
One, it's not necessary, strays away from the curriculum. Two, that's an opinion, and you're paid to teach factual information.
Okay, very good. You saw 13, or you knew it. Either way, you got the answer right. Very good. Teachers get paid to teach the curriculum. They don't get paid to teach their opinions. This is very clear. There's a case that was just recently decided by the Seventh Circuit Court of Appeals, the federal appellate court that governs Illinois, Indiana, and Wisconsin. The Mayer case, M-A-Y-E-R. Mayer was a first-year teacher who expressed her views about the war in Iraq and was fired at the end of the year. She contended it was the result of her comments about the Iraq war, and that dismissal violated her academic freedom, her First Amendment rights, okay, to express her opinions in class. The Seventh Circuit Court of Appeals said teachers are paid to teach the curriculum as prescribed by their boards of education and by their superiors. Okay? So even if the board did dismiss her for that reason, it would be okay. There had been no trial, there were no facts, and so we don't really know why she was fired. All we know that as a matter of law, the Seventh Circuit, which governs us, in a 2007 case, has said you can't get fired for your own opinions. So what lesson does that convey to us as new untenured teachers? Yeah, stick to the curriculum, all right? Okay. Now, have I seen, go ahead.
I was just going to ask how that relates to, like, coaching, for example, and opinion stated, and...
That would be a different scenario. The coaching, you mean as far as, yeah, well, I mean, you're talking about in the context of zone versus man-to-man, or are you talking about?
No, I'm talking about a statement that may be made about
A certain player?
certain player or process.
Well, that would not be, the way that we handle sports and coaches, they're given a great deal of leeway. Now, within those boundaries of being able to assess student talent, player talent, to be able to determine what offense or defense we're going to run, they're given a lot of leeway that would not be applicable to the Mayer case, okay? Please.
The situation, what he's talking about here, happened. A first grade teacher had outside her room pictures of the war in Iraq with little kids being dismembered and blown up. And she was opposed to it. She was placing those on the walls. This happened in the school where I was at. And told her to take it down.
Yeah.
And she didn't want to. We took it down.
Yeah.
And that was it, because you couldn't, that was scaring kids. And it was not appropriate. And she knew she couldn't win that. So you can't do that.
Yeah. Okay. Let's flip on, shall we? Number 16, which reads as, someone read it for me. Okay. Okay, in Illinois, a teacher's right to his or her own private life is not the same as any other citizen's right. Okay? And that's true and that's false. Okay? We no longer live in the days when all teachers had to be single, unmarried women. Okay? And once you got married, then you couldn't be a teacher anymore. We've moved away from the days where, if you had longer hair or you had facial hair, you maybe were asked to find employment elsewhere. Okay? But at the same time, you've got to realize that you are a public figure and you are a public employee. And therefore, behaviors that you exhibit outside of the school can be used against you at a later date. Okay? And there are many cases on the books where it's demonstrated where people's ability to teach, okay, their effectiveness as a teacher, has been compromised by their behavior outside of school. All right? So particularly, let me caution you, as a new, non-tenured teacher, you can be released, as one of the questions illustrates, and as I'm sure you know, you can be released without any reason being given at all. So if you're in a conservative town, okay, you need to know your audience. It'd probably be a good idea for you never to step foot in a bar in that town, would be my guess. Okay? Because, you know, you just never know what may trigger a problem for you. Okay? Enough said on that? Okay. Use some common sense. How about schools regulating teacher dress? Well, again, it's not like the old days where we checked skirt lengths, etc. But certainly, if your dress interferes with the learning environment, that's going to be a problem, and you can be disciplined as a result. So, not only for your future employment purposes, but also for your effectiveness, you need to dress professionally. You are a professional. You're no longer a college student. Your age in relationship to the kids is narrow enough now. They're going to have a hard time looking at you as a really an authority figure. You're more like a peer. So one way you can distinguish yourself is through your dress. Okay? So a couple reasons there that you want to dress professionally. All right. A school board may not require that its employees be residents of the district. Okay, that's true and false. If it's made, Chicago is the exception. Okay, if you're looking to teach in Chicago, you must be a resident of the Chicago district. Downstate, you don't have to be a resident as a teacher. If you're going to be a principal or superintendent, though, and that's made a condition at the time you're employed, then you can be required to live within the district. All right? Okay, 20. Willful and wanton misconduct is a course of action which shows actual or deliberate intention. Now, I've changed this a little bit from the handout. And the reason I did it, I was putting this together on a timeline, and I put down the common law definition. This is the actual definition, as I got to thinking about it, that I like to give you. This is the one that actually comes out of the Tort Immunity Act. The Tort Immunity Act is that statutory provision that protects teachers, okay, from being sued. Okay? And in order for you to be sued successfully in Illinois under the Tort Immunity Act, that's accurate, but this is even more accurate, what it says, that willful and wanton misconduct, your behavior, is a course of action which shows actual or deliberate intention to cause harm, or which shows an utter indifference to or conscious disregard for the safety of others. We're not talking about negligence here. Negligence is when you don't behave like a reasonable person should, as a reasonable and prudent person should. If you're outside the school and you run a stop sign and you hit somebody, that's the standard upon which you would be judged. Well, were you behaving as a reasonable, prudent driver would have? Okay? That's a fact question to be determined by the jury, and it would determine whether you would be found liable or not. In a school setting, when you're acting within the scope of your employment, you're protected from those kinds of suits. Okay? It doesn't mean you can't get fired for acting negligently, or that can't have some kind of problem for your employment. But what it does mean is that schools and teachers, unless you are acting almost intentionally, you're going to be shielded, immunized from liability. Now, what's an example of that? Recent case out of Chicago. This was a case that was at a youth center affiliated with the school, but it's the same principle because the guy was a public employee.